Good afternoon, everyone. Thank you very much for coming, and thank you to those of you who have signed in online. My name is Shawna Ramsay, and I am a national consultant with TitlePLUS. And the topic that I'm here to present to you today is TitlePLUS Substantive Policy, what's covered and what's not. I'm going to go through the coverage that's contained in the policy, as well as the exclusions and some of the potential exceptions to coverage. We'll also take a look at a few endorsements that could be attached to a policy, and then I'm going to go through the claims process with you. Once I come to the end of my session, I'm going to take a few questions, but please note that I'm not going to be able to answer any questions about specific claims scenarios, and that's because each claim is considered on an individual basis and in accordance with the terms of the applicable policy for that transaction. We decided to walk the streets of Toronto and interview some individuals just to see exactly how much Canadian homeowners know about title insurance. So I have a video that I'd like to play for you.
What do Canadian homeowners know about title insurance? Let's find out. What is the best thing about owning a home?
The best thing about owning a home is the fact that you've invested in your future.
Freedom.
That you don't have to pay rent.
When have you regretted being a homeowner?
Signing the mortgage.
Oh, when things fall apart, you have to fix them.
When I had to pay bills.
When I had crappy neighbors.
What types of insurance do you have for your home?
I don't even know. My husband does that. The most extended insurance.
Fire theft. All of those bells and whistles.
What is title insurance?
I've no clue.
My lawyers told me about it when I was signing up, and it's basically to protect the title.
So you're covered if anyone does fraudulent acts on your property.
Title insurance secures the transaction when you purchase a new home or a resale house.
Title is your ownership of your home. Title insurance is an insurance policy that protects you against problems with your title. How is title insurance different than home insurance?
Well, I guess home insurance would cover the building.
Fire or theft damage that may occur in a home. Title insurance is about the ownership of the home and making sure that you have what you paid for.
Title problems could include buildings outside the property line. How can your title be stolen or mortgaged without your knowledge?
I wish I knew.
Identity theft.
A TitlePLUS policy provides coverage for title fraud that may have occurred prior to your purchase or if your property becomes a target at a later date. Would you be covered if the previous owner didn't pay their property tax bills?
I don't think I would be. I'm going to say yes. I'm actually not too sure what my insurance covers.
A TitlePLUS policy may provide coverage for property tax bills which the seller should have paid but didn't. How often do you pay premiums for title insurance?
Monthly?
Just at the time, the initial time when you buy the home.
Maybe annually?
I don't know. Maybe I don't even have title insurance. I have no idea.
Title insurance is usually purchased when you buy a home. Unlike other types of insurance, the premium for a TitlePLUS policy is paid only once for as long as you own the home. How does buying title insurance save you money?
I'm not sure if it does.
Hidden cost down the line.
Safeguards you against any probable loss which may arise out of the bad title.
It reduces your costs because some searches and a survey may not be needed. To learn more about TitlePLUS title insurance, contact your real estate lawyer.
So the general consensus seems to be there's a bit of confusion out there about title insurance. I think a good place to start when you're reviewing an insurance policy is to understand the format of the policy jacket. Under a TitlePLUS policy, we're combining both owner coverage and lender coverage inside that one jacket. At the beginning of the policy, there are several different clauses which will list coverage that applies to the owner. And then later on, there's a section that's called mortgage provisions. That section begins to identify coverage that is applicable for the mortgage lender. In 2006, we added something called a supplementary coverage endorsement to our policy, and that can be found at the very back. This endorsement is doing two things. First of all, it amends some of the coverage that's contained in the main part of the policy. And second of all, it adds lots of additional coverage to the policy. Some of that coverage is applicable as at the policy date. And the policy date is the closing date that's entered into the policy application, whereas other coverages are effective even after the policy date. For the purposes of today's presentation, I'm going to be focusing on the owner coverage. There's really no question that there's an awful lot of value that can be found by having a survey available. A survey will show you things like encroachments, expropriations possibly. It can also show you the distance between the house and the lot lines. However, having a survey prepared can be very expensive, and it also takes time. And it seems as though lately an agreement of purchase and sale will come in, and you could be expected to close that transaction within a couple of weeks. So there isn't always enough time to have a survey done. The coverage that's provided in a TitlePLUS policy is available without the need to obtain an up-to-date survey. So this is one of the areas where purchasers have extensive cost savings. There are several clauses in the policy that address coverage relating to surveys. The first clause that I want to take a look at is more of a general coverage clause. It provides coverage for any violations or variations that would have been disclosed by an up-to-date survey. Now, it's also important to recognize when these coverages apply. This particular coverage is triggered in the event that the insured is unable to enforce the closing of a sale, lease, or mortgage of the land. Another clause provides coverage for encroachments and setback deficiencies, and this particular coverage is triggered if the insured is being forced to fix the problem by a court or some other authority. Another clause provides coverage if existing structures are not located on the land itself. There is also coverage for expropriations that occurred as at the policy date. And last but not least, if the owners decide to go away on vacation, they come back in a couple of weeks only to find that their neighbors have built a beautiful new garage that encroaches onto their land, they can submit a claim under their TitlePLUS policy. The next area of coverage that I'd like to take a look at is unmarketability of title and conservation authority approval. I'd like to make a note of the fact that in 2016, there was an amendment to the definition of the term unmarketability in a TitlePLUS policy. And the important thing to note here is that matters relating only to the physical condition of any improvements on the land do not necessarily cause title to be unmarketable, unless notice is registered on title or the matter falls within coverage provided by other risks listed in the policy. For instance, if a house shifts and causes a structural issue, that does not necessarily make title unmarketable. There must be something that has been registered on title, or if there was a work order that existed as at the policy date, then that could fall under the work order coverage. I can, however, give you an example of something that would cause title to be unmarketable, or I should say could cause. Let's say, for instance, there is a sale by an estate. And let's say that the deceased had 4 children. If 3 of those children consented to the transfer, but the 4th one did not, that could be a scenario causing title to be unmarketable. Now, conservation authority approval. Let's say that a property is subject to the jurisdiction of a conservation authority. When the existing residential home that's on the property was originally built, it's quite likely that the person that built that home was required to get approval from the conservation authority before they started construction. Both of these scenarios, the unmarketability of title coverage and the conservation authority coverage, are triggered in the event that the insured cannot enforce the closing of a sale, lease, or mortgage of the land. Building and zoning compliance is the next area that I'd like to talk about. Again, this is an area where the purchaser can see substantial cost savings because in most cases, TitlePLUS will waive building and zoning searches. There are just a few specific areas where we would require this. For instance, if it's a multi-unit property, if it's what we would consider a high-risk transaction, and those are defined in the TitlePLUS policy application. For instance, a power of sale, foreclosure, tax sale, those are transaction types that we would consider high risk, and we would ask you to conduct a building and zoning search. And if it is a transaction involving a resale freehold home in Sudbury, then we would also ask you to conduct a building and zoning search. Now again, for this area, there are several different clauses within the policy that have coverage pertaining to building and zoning issues. The first one is general, and it's providing coverage in the event that a problem would have been revealed if a search had been done. Another clause provides coverage for any outstanding work orders that existed as at the policy date, any breaches of zoning bylaws that occurred prior to the policy date, and any lack of building permit for the existing residential structure. If you have never personally been involved in a renovation or the construction of a new home, it's somewhat difficult to understand the exact amount of detail that's involved and the paperwork that's involved in obtaining a permit, in having inspections done, in getting occupancy. So today we're lucky enough to have a building permit issued. But in order to get to this point, there's already been a lot of work that's gone into it. First of all, we had plans drawn up. We had an engineer review those plans and stamp them. We also had mechanical drawings done up. We also didn't have municipal services on this property, so we had to have septic drawings done up. We were also subject to the jurisdiction of a conservation authority, so we took this package and sent it off to them. They approved it and sent that back, and now we're prepared to provide all of this to the building department, who then will circulate everything amongst their individual departments before they grant you this building permit. So a lot of work goes into just getting to this point. But since we've been granted the building permit, we're able to commence construction. So excavation is done, footings are poured, a foundation is poured, the structure goes up, they've done the framing, they put the roof trusses on, we've had someone come in and rough in the HVAC, we've had someone come in and rough in the plumbing, we've had the electrical wiring rough in completed, and we're ready for our very first inspection. The inspector comes in and takes a look at everything with a fine-tooth comb, and they will take one of these inspection reports and write down all of the things that they believe need to be fixed. Just so you have some idea of the types of things that these inspectors are looking at, I'm going to read maybe just the first 5 items that are on this inspection report. Number 1, add lateral bracing in the attic. 2, add blocking in the tall walls where there are continuous studs at 8 feet. 3, nail all the blocking in the crawl space. 4, add a 2x8 on the flat under the LVL in the basement. 5, add bolts and nuts on the U-shaped bracket at, and then it identifies a specific spot on the drawings. So you can see that these inspections are very, very detailed. And there can be many inspections done. They will identify issues. You will be required to fix them. Then you'll need to ask them to come back. If they find more issues, you'll have to fix them again and then get them to come back again. Then we finally get to the point where we're ready to have our occupancy inspection. And even this one has got another 13 items listed that have to be fixed. And some of these are very specific. I won't bother reading through all of them, except there is one here that I find interesting, number 7, install nosing at the top of the stairs to the basement. So right down to the very finest details, you cannot have occupancy until there are absolutely no safety issues left. And even something such as nosing is a safety issue. We've completed everything, and now we've got occupancy. So after looking at all of the detail and the paperwork that's involved in this process, you can understand why from time to time, some homeowners will either choose not to call the inspector back after they've been there once, or they choose not to get a permit in the first place. For this reason, it is very important to have this building and zoning coverage in the title insurance policy. I have a couple of claims examples for you. I'm not going to go into a lot of detail, but I just want to give you some idea of the types of things that we see. So in the first claims example, there was an ensuite bathroom that was being renovated, and they did not obtain a permit for the renovation. What ended up happening is the building department issued an order to remedy an unsafe building. So you can imagine during the renovation, it's most likely that a wall had been removed, and that was a structural wall, and now we have an issue with the entire house. In the second example, there was some faulty electrical wiring done, and the Electrical Safety Authority issued an order to remedy. Okay, so the next area that I'd like to take a look at is property taxes. In most cases, TitlePLUS will waive the requirement for a tax certificate, and there are a couple of clauses in the policy that provide coverage here. The first one provides coverage for realty taxes and local improvement charges owing as at the policy date. And the second clause provides coverage for supplementary realty taxes not previously assessed for any period prior to the policy date. I also want to mention here that the Lawyers Working Group has got a mentoring initiative on their website. Once a month, they will post a survey that contains a few questions, and each survey is on a different topic. I noticed on their website that they had posted answers to one of the surveys that contained questions about property taxes. I found it interesting that 56% of the respondents indicated that they obtain a tax certificate on all resale residential transactions. And they indicated that the reason why they do this is because they feel that there are just too many costs involved and a disruption to their business workflow if a statement of adjustments was done incorrectly or if there are monies owing. The other 44% of the respondents indicated that they do not normally get a tax certificate because the title insurance company does not require it. Third-party rights and rights of possession. There is a specific clause in the TitlePLUS policy that provides coverage for rights arising from tenancies, contracts, options, or rights of possession under the Family Law Act. I'd like to go through just a couple of hypothetical scenarios here to try and help you understand what types of things might fall under this particular coverage. I've identified the details of the first scenario on the slide here. So let's say that a potential buyer makes an offer on a home, and their offer is conditional upon the sale of their property. Let's say the seller accepts that offer, but they insist that they're able to continue to offer their property for sale, but they give this first potential buyer a right of first refusal. A new buyer comes along, makes an offer, the seller is agreeable, and they do not provide that right of first refusal to the first potential buyer. The deal then closes. This is a scenario where that first potential buyer may attempt to make a claim against the new homeowner. Now, whether at the end of the day it's a valid claim or not, the point is that there is coverage in the policy, which means that there's a duty to defend. So if that first potential buyer attempts to make a claim against that new homeowner, TitlePLUS would be defending that new homeowner against any potential validity of the claim. The second scenario here, where involving tenants, would be, let's say somebody buys a house sight unseen, and perhaps they're buying it for investment purposes. They may also have already made arrangements with someone to rent the place out. When the deal closed, nobody was aware that there were already existing tenants in the property. Now, the new homeowner can't evict those tenants, and they've already made arrangements with someone else to move in and rent the property. This is a potential right that could arise from a tenancy. And then in my last scenario, spousal rights. This, of course, would be where a spouse is trying to deal with the property. Perhaps they want to put a mortgage on the property, and they don't have that other spouse consent to the transaction. This scenario can always create a right. I have to tell you that the underwriting department at TitlePLUS is wonderful. They are extremely helpful. And they are there to take questions from lawyers when you run into a situation where there's something unusual going on and you're not sure what type of coverage might be available. And oftentimes, a discussion with an underwriter can even assist in mitigating the risk a little bit. We had one particular lawyer that contacted our underwriter because they were dealing with an estate sale. There was a transmission by personal representative, but there was no certificate of appointment of estate trustee. So our underwriters had a discussion with the lawyer, and they realized that this was a first dealing with the property since it had been converted to land titles conversion qualified. Because of that, the underwriter suggested that the lawyer take a look at the 2015-05 Teraview Changes document. In this document, section 2.1 indicates that transmission applications on land titles conversion qualified properties generally do not require a certificate of appointment of estate trustee if it is the first dealing with the lands since the ministry conversion. However, certain evidence is required to be included in the transmission by way of supporting documents from the applicant or by way of statements from a solicitor. There are 3 statements that would be required to be checked off. First of all, statement 3634, which would indicate that no application was made for a certificate of appointment of estate trustee, as this transaction is the first dealing after the property was converted from registry to land titles by the ministry, and then there is a section there where you have to enter the value of the estate. The second statement that needs to be checked off is statement 3640, and this provides an area where the lawyer is required to attach a covenant to indemnify the land titles assurance fund. The third statement that is required is either statement 3635 if a will is properly executed, or statement 3636 if the will was not properly executed. So during the discussion that the underwriter had with this particular lawyer, they had determined that all the correct statements had been checked off in the transmission application, and as a result, the risk was fairly low, and we certainly provided insure-over coverage for both the purchaser and the mortgage lender. Okay, so moving along, TitlePLUS policy contains coverage for liens and charges disclosed by registered title. There is also coverage for against the registration of any construction liens where services or materials had been furnished prior to the policy date. And this would be a good time just to mention as a reminder, on July 1st of 2018, changes were made to the Construction Act. The lien period has been extended from 45 days to 60 days, and the period of time to perfect a lien has been extended from 45 days to 90 days. Easements are very common, and of course they affect most properties. A TitlePLUS policy will cover damage to existing structures on the property due to the use or maintenance of any easement. The policy also provides coverage for unregistered hydro easements. And the policy provides protection for the validity of easements benefiting the land. One other clause that I'd like to mention is not necessarily specifically related to easements, but it's right beside the clause that provides protection for easements benefiting the land is our access coverage. And that clause provides protection for the legal right of access to and from the land. The policy provides coverage for breaches of restrictive covenants, for violations of subdivision agreements, development agreements, or other related municipal agreements. And it also provides coverage for damage to structures as a result of exercising mineral rights. Another example where we had a lawyer that contacted our underwriting department because she was dealing with the purchase of a piece of vacant land. She had reviewed the Crown patent, and while she was reviewing it, she discovered that there was a reservation in there which read that if any portion of the land was required by the Crown, that that portion of land was deemed to automatically vest in the Crown. So she contacted us hoping that we might be able to assist her by providing some sort of protection for her clients. In an effort to mitigate the risk, our underwriter asked this particular lawyer if she would be willing to send a letter to the Ministry of Natural Resources and ask them two things. First of all, would it be possible to release the reservation that was in the Crown, or that was in the Crown patent? And second of all, if not, could they please tell us under what circumstances they might exercise this reservation? So she did. She sent the letter off, and she did receive a response from the MNR, and they indicated that there was no legislative authority that would permit them to release the reservation. However, they also indicated that to their knowledge, that reservation had never been exercised in the past and probably never would be. They also noted that it is today's practice, if the Crown requires a piece of land, that they would normally either purchase it or expropriate it. So after receiving that response from the MNR, our underwriters determined that the risk was fairly low, and we agreed to provide insure-over coverage for both the purchaser and the mortgage lender. The next area is fraud, and this is a very complex area of coverage. In fact, fraud is so complex that it really warrants its own presentation. The link that I'm showing you here, and it's in your paper, is a link to a separate presentation that speaks only to fraud. If you would like to view that presentation, there is a password required. It is also noted in your paper, but that password is LawPro1210. LawPro regularly circulates information on fraud. They continuously try to help you identify red flags. They often summarize recent scams that are being perpetrated by fraudsters. But at the end of the day, honestly, the very best protection that is available for any homeowner or mortgage lender is to have a title insurance policy. The TitlePLUS policy specifically provides coverage for any fraud that may have taken place prior to the purchase, and it also provides protection against the property becoming a target of fraud after the purchase takes place. Clerical errors. The truth of the matter is, we all make mistakes. This particular area of coverage provides protection against a registered document that was completed improperly. It also provides coverage for any errors in responses to building and zoning searches. And while we're on the topic of discussing the fact that mistakes happen, the next area of coverage in a TitlePLUS policy is the legal service coverage. Now, this is coverage that is unique to a TitlePLUS policy. It's really what sets us apart from everyone else. TitlePLUS is underwritten by LawPro. Therefore, we have a license to insure a lawyer's professional liability, and that's why we've incorporated this coverage. I want to actually read you word for word one of the clauses that's included in this section. The policy reads, "This policy insures you if you suffer an actual loss in the transaction because your lawyer commits an error or omission in providing legal services for the transaction for which liability is imposed by law." Now, that's the broadest wording of the coverage that I could imagine. And I think this is really what makes TitlePLUS a preferred insurer. This coverage is beneficial not only for the clients, but it's also beneficial for the lawyer. And in the event that a mistake was made and the legal service coverage was not part of the policy, the lawyer could be sued if the issue that has come up is not something that's covered under one of the other risks in that title insurance policy. And if the lawyer is sued, then of course LawPro gets involved. And if liability is found and LawPro pays out, that lawyer will incur a deductible. There will be a claims levy surcharge, and quite possibly your premiums will increase. This is all out of the lawyer's pocket. If a mistake is made and you've used a TitlePLUS policy, which obviously contains this legal service coverage, instead of the lawyer being sued, there is direct compensation under a TitlePLUS policy, which means no deductible, which means no claims levy surcharge, which means your premiums do not go up. I think that this coverage is extremely important to recognize. And I do urge you to take a look at that coverage. There are a few other clauses that I didn't read. It can be found on page 3 under the legal service coverage heading. Okay, the next area is continuation of coverage. This clause allows the coverage under a TitlePLUS policy to continue to be in full force and effect even if the property is transferred to a spouse, a child, or anyone who inherits the land. It would also continue if the property is transferred to a trustee, where the insured is the settlor of the trust. It would also continue if the property is transferred to a beneficiary under the trust. And then a couple of other different scenarios to note, which I find lawyers are generally unaware of. This one here applies to vendor take-back mortgages. If you purchased a property and you obtained a TitlePLUS policy, and then the insured later on sells that property but gives a vendor take-back mortgage, the TitlePLUS policy that they originally got continues to be in full force and effect for that vendor take-back mortgage, even though they've sold the property. Another area here, so again, if an insured purchased a TitlePLUS policy and then later on sold the property, but continues to be liable for covenants that they have given with respect to risks that are covered under the policy, that policy continues to be in full force and effect for those covenants. And then lastly, a TitlePLUS policy will continue to be in effect for an insured mortgage that is extended, amended, or assigned. It's important to note that if you're dealing with vacant land, when the policy application is completed and you indicate that the property is vacant land, automatically there is a blanket exception to coverage that is inserted into the policy. When it's vacant land, there is no coverage for zoning contraventions. That exception also explains that if there is new construction, that construction will be subject to the applicable laws, as well as any restrictions or agreements that are on title. And lastly, there is no coverage for building issues, and that's of course because there is no existing structure on the land. Now I'd like to discuss some of the endorsements that are available with TitlePLUS. The first 2 endorsements that I'm going to talk about will attach to the policy automatically when the circumstances warrant it, and the rest of them are available and you can request them. So the first one is the Condominium Endorsement. When you complete the TitlePLUS policy application and indicate that the property is a condominium, this will attach automatically. The endorsement will provide coverage for liens for common expenses and special assessments that were not disclosed by the status certificate but should have been. It also provides coverage for any non-compliance with the condominium declaration, bylaws, or rules. And it provides coverage for any unapproved modifications to the common elements. The rural property endorsement will attach automatically if, when you're completing the policy application, you indicate that the property is not serviced by municipal water and sewage services, in which case we assume that it must be on well and septic, and we're going to attach this endorsement. The endorsement provides coverage for work orders against either a well or a septic system. It also provides coverage for the lack of a permit for the septic system. And it covers the lack of septic approval where improvements were made to the land. Now, all of this coverage that relates to the septic system is available and provided automatically, even though we do not require you to search for a septic use permit. It applies to both the owner as well as the mortgage lender. The coverage here that relates to the well is provided automatically for the mortgage lender without the need to obtain a copy of the water potability certificate. However, if you would like the coverage with respect to the well for the purchaser, then we would ask you to please obtain a copy of the water potability certificate. Okay, so the rest of these endorsements that I'm going to go through are available upon request. The first one is the increased policy amount endorsement. If a home has been renovated and there has been a substantial increase in the value of the home, or if it was originally vacant land when it was title insured by TitlePLUS, and since then there has been a house built on the land, I highly recommend that you request an increased policy amount endorsement. And the reason why I highly recommend this is because the policy amount is equal to the purchase price that was entered in the TitlePLUS policy application. And that is the amount that is available in the event of a claim. The fee for the endorsement will be equal to the difference in the premium based on the new value of the property. The ancillary unit policy was designed to accommodate situations where a builder or developer is transferring title to a locker or a parking space at some point after the transfer of the dwelling unit. The policy cost for this is the equivalent to the cost of a mortgage-only policy. The change of ownership endorsement was designed to accommodate transactions where there is a transfer of the property, and usually for tax reasons. So for instance, there may be a transfer from an individual to a corporation or vice versa, or sometimes there's a transfer from one corporation to another, or even potentially from a trustee to a beneficiary. The charge for this endorsement is $50 plus tax, and the effect of obtaining this endorsement is to allow the coverage that was contained in the original TitlePLUS policy to continue to be in full force and effect for the new owner. The part interest endorsement is used where one party transfers a partial interest in the property to a third party. Now, there are some requirements in order to be eligible for this endorsement. The property must have either been originally insured by TitlePLUS, or it must not have been title insured at all. And the reason why this is a requirement in order to be eligible for this endorsement is because we do not want a scenario where TitlePLUS is on record for title insurer and there's also another company that's on record as title insurer for the same property. That may potentially cause a conflict. The charge for this endorsement varies depending on the circumstances. Okay, there are specific issues that are excluded from coverage in a TitlePLUS policy. The first one is the exercise of governmental power or discretion. An example of this would be if a bylaw was passed changing the zoning of the property. That is not covered under the policy. Secondly, dangerous or hazardous substance on the land. For instance, TitlePLUS will not cover an oil spill. The inability to construct improvements on the land. An example here would be if there was a conservation authority that had jurisdiction over the property, and let's say a portion of the property is deemed to be protected environment and you're not allowed to build on it. There is no coverage for something like that. Native or Aboriginal land claims are excluded from coverage. There is also a general knowledge exclusion. Of course, if you are aware of a problem, then you need to disclose that to the title insurer. And lastly, there is an exclusion if the owner fails to comply with the building code. Exceptions to coverage are generated by information that is entered into the policy application. Oftentimes, you may find title defects in here or any specific issues with the property. They can be found on Schedule A, which is attached at the back of the policy. Policy amount and inflation coverage. So I mentioned earlier, the policy amount is equivalent to the purchase price, but there is a clause in the policy that provides for inflation. So the purchase price will increase along with fair market value, up to a maximum of 2 times the original purchase price. Oh yes, and the increase will be determined, of course, when the claim is made. Okay, so now we're on to the claims process. First thing I want to mention here is if a client thinks that they may have a claim, it's important that they give us notice of that claim as soon as they become aware of it or as soon as reasonably possible. A claim can be submitted either by the insured or by the lawyer, and you should attach any documentation that you feel is relevant to the claim. There is a proof of loss form that is used to commence a claim, and that can be found on our website at TitlePLUS.ca under the heading Policyholder Information. A TitlePLUS policy provides us with a few different options when we're resolving a claim. We have the right to repair or replace the structure. We can choose to pay the diminution in the property value. We can choose to negotiate a settlement, or we can take the matter to court. The clause also provides for a duty to defend. We will defend an action against any third-party claims if it's caused by a matter that's covered under the policy. We pay the costs, the legal fees, and the disbursements. Now, we can end our duty to defend if we choose to use one of the options that we have in resolving the claim. For instance, if we decide to negotiate a settlement, then we can end our duty to defend. The policy also contains a clause which provides rent for reasonable substitute accommodations when necessary. And one other thing to note here, it is important to wait when you're in the process of dealing with a claim. Wait until you hear from the claims adjuster. Wait until they give you some instructions on how to move forward, because any costs that are incurred must be approved by TitlePLUS. So you don't want to incur any costs until you've spoken with us and confirmed that this is how we want to move forward. Okay, so that brings us to the end of my policy review. Just going to take 1 minute, and once again, as I always do, I'm going to ask you for your support. Please support the TitlePLUS program. We are your bar-related title insurer. We have a great policy. We have great coverage. We're always working to improve efficiency and anything that we can. We also have consultants here today. At the table here we have Dexter Jow, we have Roop Gruel, and over there we have Jamie Smith. If anyone is interested in meeting with a consultant to discuss TitlePLUS, if you need training or anything at all, we are happy to help. Okay, so we have some time. If there are any questions, I can certainly attempt to answer those best that I can. If anybody in the room has a question, if you don't mind, there are microphones at both sides of the room. Just read your question into the microphone so that everybody online can hear you as well. So I haven't had any questions come in yet from online. Any in the room? Okay, well, if there aren't any questions, what's that? Okay, sure.
What is a will that has not been executed properly, and when would a lawyer ever agree to make a statement like that, saying that the client that he's acting for is purporting to transfer a property under a power of a will that was not executed properly?
I would love to be able to say that I can answer that question. Honestly, I'm just going by the Teraview guidelines document, and that is exactly what the Teraview statement says, word for word. So when would a lawyer select that statement? I'm not really sure, but that is an option that they have outlined for one reason or another. Any other questions? Okay, I'm going to wrap this up. Our next speaker is Lisa Weinstein.